Hello, welcome to Another Thing. I'm Larry Menti. By now, we all know about the stalemate between the FBI and Apple, and we all undoubtedly have taken sides. The issue is an Apple iPhone used by one of the terrorists in the San Bernardino attacks that killed 14. The FBI says it can't get into the iPhone without Apple's help, and they got a court order to force Apple to do just that. Apple says if they break into this one phone, they create a backdoor that can be used by hackers and terrorists to break into all of our iPhones. And they are fighting the court order. Now that sets up our discussion of national security versus individual privacy. And we begin with Ellen Kolodziej. Ellen.
Thank you, Larry. Well, this is certainly shaping up to be a battle of epic proportions. The FBI versus Apple, national security versus privacy rights. And it all boils down to the government demanding that Apple unlock the iPhone of a terrorist.
The only way we know would be to write a piece of software that we view as sort of the software equivalent of cancer. We think it's bad news to write. We would never write it. We have never written it.
Apple's CEO says if Apple does what a court has ordered to unlock the phone of one of the San Bernardino shooters to get more information about the attack, it would set a dangerous precedent. But at congressional hearings on this issue, many lawmakers and the head of the FBI strongly disagreed.
But I do think the larger question is not going to be answered in the courts and shouldn't be, because it's really about who do we want to be as a country and how do we want to govern ourselves.
I think Apple leadership risks having blood on their hands. And I think Tim Cook is going to have a very hard time explaining why he stood in the way of justice.
You have to figure out a balancing, though, here. And I think that's what Apple's doing, pushing back. And Apple's right to push back because as a business, you certainly, if Apple would just roll over, I probably would never buy another iPhone. I don't know that you would. I don't know that anybody would because we'd go, well, wait a minute. Why would I do this if my security is now compromised?
Rick Grimaldi is the chair of government relations for the law firm Fisher & Phillips. He believes this is about much more than just one phone, as the FBI claims.
It's an extremely important case, maybe the most important case that we're seeing right now and the most important issue, which is why even our political candidates don't quite know where to come down. The public split really roughly 50-50 in support of Apple and the government.
Now, the families of those victims in California, well, they're even asking Apple to please help the government. But this case will not be settled quickly, and most experts agree this will end up in front of the Supreme Court. Reporting for Another Thing, I'm Ellen Kolodziej.
Now to talk more about the FBI versus Apple over a terrorist cell phone is David Opderbeck, who is a professor of law at Seton Hall Law School. Do you have a dog in this fight? Do you think one side or the other is right or wrong?
I think it's tough to say absolutely that one side is right or wrong. I did file an amicus brief in the current case in California. The brief doesn't take a position on either side, but it does argue that the government did have the proper legal authority, at least to issue the order that it did issue.
They did have the proper legal. Right. Why is that? On what basis?
Well, they issued valid search warrants for the phone, and then under those search warrants, they issued an order under a statute called the All Writs Act. There is a Supreme Court case from about the 1970s that deals with a somewhat similar issue. And the majority of the Supreme Court upheld the authority under the All Writs Act to compel something similar. It was a pen register, which is a way of tracing telephone numbers. And in my view, that precedent controls this court in this case.
All right, let's back up a little bit. Apple doesn't own the phone, right?
That's right.
And so you're issuing a warrant for someone that doesn't own the phone?
Well, you're issuing a search warrant to the owner of the phone, which is the San Bernardino
But that doesn't
County.
compel Apple to do anything.
No, but then the court issues an order under the All Writs Act asking for Apple's or requiring Apple's assistance in the execution of that warrant, and that's what the All Writs Act does. It's a statute that was signed into law by the first Congress, signed into law by President George Washington, that from time immemorial in our law has allowed federal courts to require assistance in the execution of other orders.
What's the probable cause on the warrant?
Well, there's no issue about probable cause. I mean, there's no doubt that the shooter had the phone. There's no doubt that the person was the shooter. So the probable cause is that a crime has been committed. I don't think there's any doubt about that.
You don't have to give probable cause to say that we know something's on there or we suspect something's on there that's going to help us? Because if the crime's already been committed, you would now have to make the argument that you're preventing a future crime.
Right. No, I mean, you have to separate probable cause for the search warrant from the authority under the All Writs Act. Those are two different things.
Okay.
No one's disputing, not even Apple is disputing, that there was probable cause to issue the search warrant. I mean, that's absolutely crystal clear. If a mass murderer, a shooter, alleged shooter, has a cell phone in his possession and conducts this crime, there's no doubt that there's probable cause to search that phone.
No, I'm not saying that. I'm asking if there's probable cause to compel Apple to help them because of the probable cause that something's on the phone.
Right, that's why you need to separate the search warrant from the All Writs Act. The All Writs Act is not a probable cause issue. The All Writs Act is that the federal court has issued some kind of valid order or process. It doesn't have to be a search warrant, it can be any kind of valid order or process, and requires some kind of assistance in the execution of that valid order or process. You don't need to show probable cause for that. You need to show what's essentially a balancing test, that there is some legitimate need for the government to have this assistance, and the assistance won't be overly burdensome.
Explain to me how the All Writs Act is constitutional. Explain to me how they can force me to help them in an investigation against somebody else.
Yeah, I mean, this is a really interesting legal issue, and it was settled by the Supreme Court in U.S. v. New York Telephone. So in the New York Telephone case, the question was, could the government, under the All Writs Act, compel a telephone company to help place a device that would trace telephone calls, right? The majority in the Supreme Court in that case said, yes, they can. That writ is constitutional. It's kind of an ancient statute in our law. It doesn't place an undue burden on the phone company. There was a dissent in that case that argued that the way the statute was being used was very similar to the way the British used something called writs of assistance before the Revolutionary War, and that was one of the things that touched off.
Is this when they used to take your home?
Yeah, they just do things like that.
Isn't that what the Fourth Amendment's all about?
Well, it's not really a Fourth Amendment issue because...
Well, Fourth Amendment's illegal search and seizure, right?
Yeah.
When you force Apple to create something that you could then use in the future, even though I know the FBI says that's not the case, if they're correct in saying that, aren't you seizing their intellectual property?
No, I don't think so. I mean, that's a separate issue. Search and seizure has to do with if there is kind of criminal cause for searching something. The kind of thing you're getting at, I think, is an argument people have been making based on the First Amendment. Can you compel someone to speak? It's absolutely clear that software is speech under the First Amendment, so that is an issue, and it is an important thing to raise. But there are plenty of circumstances under which the government can compel any of us to speak. You can be issued a warrant to testify in court. You have to speak under the penalty of contempt.
Now, you're the law professor, so forgive me. Take a step back for a second. If you have a company and I force you to make something, and then knowing that I can take that from you or use it, how is that not illegal search and seizure if I'm taking something from you?
Well, it's not a search and seizure issue because it's not a criminal process issue. But what you're really talking about is some kind of due process issue. And think about it, there are plenty of circumstances, many circumstances under which the government requires you to make something if you're a business. Think about automobiles. You have to make certain kinds of safety.
But then they don't take it.
No, but the government has certain rights over your business if you don't use that equipment. You can be fined, for example. So think about the dispute that just arose recently with Toyota and the software that monitors emissions. The government requires them to make that software to monitor emissions. They messed it up. They're going to face a fine. There's absolutely nothing unconstitutional about that in general.
David Opderbeck, professor of law, Seton Hall Law School. Did I get it right?
Yes.
Perfect. When we come back, do you have a student loan? Maybe you can get your employer to pay it off. There are employers that are doing just that, and we'll talk about that when we come right back.